Hey all, Glenn Kirshner here. So friends, a federal judge appointed by President George H.W. Bush just laid down the law to Donald Trump and his lawyers for their abuse of the rules of procedure that apply to everyone in federal court. Let's start with the new reporting. This from Politico. Headline, Judge tosses Trump's $15 billion lawsuit against New York Times. And that article begins, a federal judge threw out President Donald Trump's $15 billion lawsuit against the New York Times, calling it an undignified public relations exercise meant to rage against an adversary rather than present a well-reasoned legal case. This quote from the judge, quote, as every lawyer knows or is presumed to know, a complaint, that's the document you file to commence a lawsuit, a complaint is not a public forum for vituperation and invective. U.S. District Judge Stephen Mereday, an appointee of George H.W. Bush, said of Trump's 85-page grievance-laden lawsuit. A complaint is not a megaphone for public relations or a podium for a passionate oration at a political rally or the functional equivalent of the Hyde Park Speaker's Corner. Judge Mereday gave Trump's attorneys 28 days to refile the lawsuit and ordered it to be limited to 40 pages, saying Trump must follow the rules requiring complaints to be clear and precise. He, the judge, said the lawsuit, if it proceeds, must do so in a professional and dignified manner. The scathing takedown by a Florida-based federal judge is not Trump's first. U.S. District Judge Donald Middlebrooks, a Clinton appointee, in 2022 tossed a similarly sweeping lawsuit by Trump against Hillary Clinton and numerous other adversaries, and later fined him and his attorney Elena Habba $1 million for what the judge said was a completely frivolous case. And friends, if you'll bear with me for a few minutes, I want to read select portions of Judge Mereday's 4-page order throwing out Donald Trump's complaint. It'll take me a few minutes to get through it, but I think it'll be worth your while, and I'm going to try to read it with the appropriate emphasis. So with that in mind, in the case of President Donald Trump versus New York Times Company, order. As every member of the bar of every federal court knows or is presumed to know, Rule 8A, Federal Rules of Civil Procedure, requires that a complaint include a short and plain statement of the claim showing that the pleader is entitled to relief. Rule 8E1 helpfully adds that each averment of a pleading shall be simple, concise, and direct. Some pleadings are necessarily longer than others. The difference likely depends on the number of parties and claims, the complexity of the governing facts, and the duration and scope of pertinent events. In this action, a prominent American citizen, perhaps the most prominent American citizen, alleges defamation by a prominent American newspaper publisher, perhaps the most prominent American newspaper publisher, and by several other corporate and natural persons. Alleging only 2 simple counts of defamation, the complaint consumes 85 pages. Count 1 appears on page 80, and count 2 appears on page 83. You can already see where the judge is going, friends, can't you? Even under the most generous and lenient application of Rule 8, the complaint is decidedly improper and impermissible. The pleader initially alleges an electoral victory by President Trump in historic fashion by trouncing the opponent and alludes to persistent election interference from the legacy media, led most notoriously by the New York Times. The pleader alludes to the halcyon days of the newspaper, but complains that the newspaper has become a full-throated mouthpiece of the Democrat Party, which allegedly resulted in deranged endorsement of President Trump's principal opponent in the most recent presidential election. The reader of the complaint must labor through allegations such as a new journalistic low for the hopelessly compromised and tarnished gray lady. The reader must endure an allegation of the desperate need to defame with a partisan spear rather than report with an authentic looking glass, and an allegation that the false narrative about The Apprentice was just the tip of the defendant's melting iceberg of falsehoods. Similarly, in one of many, often repetitive and laudatory toward President Trump, but superfluous allegations, the pleader states, The Apprentice represents the cultural magnitude of President Trump's singular brilliance, which captured the zeitgeist of our time. Friends, I promise I tried to get through that one without laughing. The judge's order continues. The complaint continues with allegations in defense of President Trump's father and the acquisition of the Trump's wealth, with a protracted list of the many properties owned, developed, or managed by the Trump Organization, and a list of President Trump's many books with a long account of the history of The Apprentice, with an extensive list of President Trump's media appearances, with a detailed account of other legal actions both by and against President Trump, including an account of the Russian collusion hoax and incidents of alleged lawfare against President Trump, and with much more persistently alleged in abundant, florid, and enervating detail. Even assuming that each allegation in the complaint is true, of course, that is for a jury to decide and is not pertinent here. Even assuming that at trial the plaintiff offers evidence supporting every allegation in the complaint, and even assuming that after finally melting the defendant's alleged iceberg of falsehoods, the plaintiff prevails for each reason alleged in the complaint, even assuming all that, a complaint remains an improper and impermissible place for the tedious and burdensome aggregation of prospective evidence, for the rehearsal of tendentious arguments, or for the protracted recitation and explanation of legal authority putatively supporting the pleader's claim for relief. As every lawyer knows, or is presumed to know, a complaint is not a public forum for vituperation and invective, not a protracted platform to rage against an adversary. A complaint is not a megaphone for public relations or a podium for a passionate oration at a political rally or the functional equivalent of a Hyde Park speaker's corner. A complaint is a mechanism to fairly, precisely, directly, soberly, and economically inform the defendants in a professionally constrained manner consistent with the dignity of the adversarial process in an Article III court of the United States of the nature and content of the claims. A complaint is a short, plain, direct statement of allegations of fact sufficient to create a facially plausible claim for relief and sufficient to permit the formulation of an informed response. Although lawyers receive a modicum of expressive latitude in pleading the claim of a client, the complaint in this action extends far beyond the outer bound of that latitude. This complaint stands unmistakably and inexcusably athwart the requirements of Rule 8. This action will begin, will continue, and will end in accord with the rules of procedure and in a professional and dignified manner. The complaint is struck with leave to amend within 28 days. The amended complaint must not exceed 40 pages, excluding only the caption, the signature, and any attachment. Ordered in Tampa, Florida on September 19, 2025. Signed, Stephen D. Meriday, United States District Judge. So, friends, in substance, Donald Trump and his lawyers were just called out by a federal court judge for beclowning themselves. And the judge threw out the suit, struck the complaint, and essentially cautioned them, look, if you're going to try to pursue this lawsuit, you're going to do it in accordance with the rules, like everybody else, because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.